Alright. Ready? Mm-hmm. You can do the intro whenever.
Oh. Welcome back to our channel. We're gonna watch Darrell, I think is how he says his name.
Yeah, Darrell.
Darrell, the guy that drove through the
Waukesha parade.
The guy that drove through the Christmas parade in Wisconsin.
Yeah.
A little over a year ago.
Because I've been obsessed with his case because it's
very obsessed.
It's just a perfect example of a narcissistic manipulator and abuser, and it's fascinating. So we're gonna watch the top 5 times he thought he knew the law, because he really thought he knew the law and he did not. So let's go.
You said you wanted to raise a legal issue. What's the legal issue?
The legal issue is how is the state allowed to coach the people?
You're assuming they spoke to them and coached them.
It's obvious. I'm not stupid.
Well, I disagree with that, sir.
We review when Waukesha parade
stupid.
defendant
I
Darrell
disagree with
Brooks,
that,
who
sir.
represented himself, thought he knew the law, but got it so wrong. Welcome to Sidebar, presented by Law and Crime. I'm Jesse Weber.
Oh, also, yes, this is Law and Crime. We will put the link in the description to their video. Please don't copyright strike us. This is fair use, Law and Crime. We're reacting and adding value or whatever. Don't copyright strike us. Oh, Lord.
Address subject matter jurisdiction.
The written decision that I previously entered is what I will stand on. I'm not going to address it any further.
Can we address subject matter jurisdiction and still has to be proven for the record?
No.
I decline to do so.
Is that including verified proof that you have subject matter jurisdiction? Because it has yet to be verified or proven.
Yes, it has.
Mr. Brooks, you keep making that statement, but it's a misstatement of the requirements in the law.
So it doesn't have to be proven?
You are going to get
No,
a written decision.
it doesn't.
That's how I'm addressing this. And then I'm going to have the jury brought out and just providing courtesy copies to the parties as I had an opportunity to finalize that over the break.
Set for value and return for value is document.
Thank you for noting that. All right, bring the jury out. State has its next witness, I presume, ready to go? All right. When the jury's brought out, you may call the witness.
Poor Judge Darrow.
Is
That
that
poor
verified
woman.
proof that you have subject matter jurisdiction?
The decision and order speaks for itself, sir.
Is it verified proof? that
She
you
already
have?
wrote you a
Sir.
ruling.
I believe it answers your questions.
I don't believe so.
Unequivocally,
There's no verified proof proving
He
yet.
likes to hear himself speak.
Yeah. Yeah, he
There's no
does.
verified proof if we're in common law or admiralty law. What court is this?
Look out the window. Do you
sir,
see
I
water?
believe your answers will be in that decision and order.
I don't believe so.
Well, have you
Because
read
you're
it
not
yet?
very bright.
I don't have to.
Many times during the course of this trial, Darrell Brooks brought up the issue.
Okay, so subject matter jurisdiction, as I was explaining earlier, means it's like if you have a traffic ticket, but they're trying you
Yeah.
in appellate court. That would be subject matter jurisdiction. If you murdered somebody, but they're trying to try you in traffic court, that would be subject matter jurisdiction. You murdered 6 people, bro. You murdered 6 people and injured dozens and dozens more people. You're in circuit court. That means they have subject matter jurisdiction. She wrote a ruling and gave it to you. You ripped it up, threw it away, didn't even read it, and said, I don't believe that. I don't believe that shows subject matter jurisdiction. Yes, it does. She proved to you she has subject matter jurisdiction, but you didn't even bother to read it. You tore it up and threw it away. It's on video. I'll try to insert it here. But you tore it up and threw it away and said, I don't need to read it. It doesn't prove. You don't read anything. And even if she gave you something that proved that she had subject matter jurisdiction, You would ignore it and say, no, that doesn't prove it. No, I don't buy that. I don't believe it. Because you don't actually want proof of anything. You're just trying to be a stupid-ass sovereign citizen. That's all.
Basically, you don't try a murderer in family court.
Exactly. If you murdered somebody, you don't go to family court. What he's talking about is in persona jurisdiction. Whether you have jurisdiction over my personal body. Which, yes, they do, because you committed those acts in Wisconsin, in the county, which this court has jurisdiction over. So, yes, they have in persona jurisdiction. And they have subject matter jurisdiction. But you don't want to read any of that. Sovereign citizens are idiots. Don't be a sovereign citizen. You look like a fool.
Not if I'm not allowed to face my accuser, Your Honor. My accuser in this matter would be the state of Wisconsin. And with all due
Sir, I believe your
respect,
Sixth Amendment rights in that regard have been complied with.
I'm requesting a written judicial finding of fact and
Denied.
conclusion of law on this issue for the grounds that I just stated. It was seen, based on the Sixth Amendment, that I'm not being awarded the chance to face my accuser, which I should be awarded that based on the Sixth Amendment. If I'm not able to face my accuser, then how can the claim even stand? How can a claim be brought against my client if I'm not able to face the accuser?
Okay, so number one, not to mention the fact that he just said, how can a claim be brought against my client if I'm not able to face my accuser? What? He's trying to say that he is only present as a third-party intervener for his client. He won't name his client because he doesn't know anybody by the name of Darrell Brooks. He doesn't recognize that name. He doesn't know anybody by that name, but he's appearing as a third-party intervener for his client, Darrell Brooks. But he won't name Darrell Brooks. But he won't name his client. But he is appearing as a third-party intervener on behalf of his client, who he won't name. But he also says, I haven't been given my Sixth Amendment right to face my accuser, but I don't recognize that name. I don't recognize these charges against me, but I need to face my accuser. Makes no damn sense. Not to mention the fact that the state of Wisconsin is represented by the district attorneys. And if you are allowed to represent your client as a third-party intervener, why aren't the district attorneys allowed to represent the state of Wisconsin? Why are you allowed to represent your client, but the DAs aren't allowed to represent the state of Wisconsin? I don't understand that.
He's not very bright.
No, he's not. And also, like, your Sixth Amendment right means you get to face your accuser, yes, but it also means, what that means is that you get to question all the witnesses against you. You get to cross-examine, call your own witnesses, and question the witnesses against you.
And he's doing all
That is facing your accuser, yes. He's been able to cross-examine all the witnesses brought against him. He's been able to call his own witnesses and question them. The Sixth Amendment right means you get to know who your accuser is, face them in court, and cross-examine their witnesses against you. That's what it means. So you can't say, oh, the state of Wisconsin is an entity, so I can't face them. So therefore, this should be thrown out. If that was the case, all you have to do as a murderer is kill everybody and say, there's no injured party. Everybody's dead, so there's nobody to face me, so I get to go free. That makes no sense. That's ridiculous. Of course, the people are represented by the state. And the people who voted for the district attorney and requested that they represent them in court, that's who you're facing. You get to question your witnesses. You get to cross-examine their witnesses. That's how you face your accuser.
Yep.
Idiot.
So
Do you
annoying.
even know the state of Wisconsin?
Grounds.
Grounds.
Grounds. Grounds.
Grounds.
So it will be also fair to state that you are not an injured party in this matter, correct?
Objection. Asked.
Grounds.
and answered.
Grounds.
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 Sustained.
Are you aware what a plaintiff is?
Objection. Grounds.
Sustained.
Grounds for sustain.
Grounds for the sustain, Your Honor.
Oh my gosh.
Okay,
he's
first of
annoying.
all, it's sustain.
Sustain, not substain.
And second, often during the trial, he would yell grounds multiple times, even as the reason for the objection is stated very clearly by the prosecution and acknowledged by the judge. Third, I should mention, he's under no duty, no legal requirement to yell out grounds every time there's something that happens.
Exactly.
Every time there's an objection. He doesn't have to do that. He can provide an answer to the state's objection, but he has no obligation to yell out grounds. So if anybody's watching that, you don't do that in a typical
No,
trial.
you don't do that. I've
Yeah.
never heard that been done in a trial, and I've been to a trial myself.
No,
So stupid.
that does not happen in trials, because if you wait a second, when I say objection, if I say objection misstates facts and evidence, or if I say objection irrelevant or relevance, or if I say objection hearsay, those are the grounds. And if the judge says sustained, not substained, if the judge says sustained, you don't have to say grounds for the sustained, Your Honor. She just told you. When the DA objected to facts not in evidence, and then the judge says sustained, you don't have to ask the grounds for the sustained, because the judge will just say facts not in evidence or hearsay or whatever. The judge will tell you. I mean, the judge is under no obligation to tell you the grounds, number one. And number two, if you just listen to the objection, you know the grounds. I believe he was yelling grounds partly because it's part of his sovereign citizen BS, and partly because he was just trying to throw everybody off. When you're trying to make an objection, or you're trying to talk, or the judge is trying to determine whether or not to overrule or sustain the objection, he's yelling grounds, grounds, grounds. It's hard to think and make your objection or determine if it should be sustained or overruled. I think it's part of his manipulator, narcissistic personality that he just keeps yelling grounds, 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 because he wants to interrupt everybody. That's what I think. I might be wrong, but I think it's possibly because he just thinks yelling grounds when everybody's trying to talk. Also, the court reporter can't take stuff down properly if there's 4 people talking at once. So if you're trying to say objection, facts not in evidence, or objection whatever, and he's yelling grounds over top of you, the court reporter can't take all that down. And he's hoping to mess up the record so that when he goes to file his appeal, the record is muddy and messy, and he can get grounds for an appeal. That's what I think.
He's so frustrating to listen to.
Yeah.
I don't know how you listen to him as often as you do, day in and day out. I can't. The guy drives me bonkers.
Yeah, he drives me crazy too. But I also know, I take comfort in the fact that I know he's buried under the prison. He
I
got
know
6
he's
life sentences plus
that,
another
but
1,000
still.
years. So
Gosh.
I just think when I get frustrated listening to him, I think about the sentencing, and I think about all the years he got, and I go, okay, I can listen to this, because I know he's going to jail for ever.
Not going. He's already there.
Well, yeah, he's in jail forever and ever and ever.
Not jail either. Prison.
Prison.
Way worse
Well,
than
he
jail.
still has cases pending in Milwaukee that he's going to. So he's in jail right now. He hasn't been transferred to prison yet because he's still got cases in Milwaukee.
Oh,
He's got a case in Nevada, and he's got a case in Atlanta, Georgia.
they won't extradite him.
They probably won't extradite him. But he does have cases in like 2 different states.
Yeah, but they're not going to waste their money on doing that, babe. That's a lot of money.
Yeah, they probably won't. But that's how I take solace. I think about the fact that, okay, he's buried under the prison. The judge gave him 6 life sentences to run consecutively, and also another 1,000 years to run consecutively. So he ain't getting out. So
No, that's fine. I just, yeah.
To specifically address the repeated requests by Mr. Brooks for the court to state the grounds, sir, I am not legally required to do that.
No,
Those are
she's
legal
not.
determinations that if you feel there is an error later on, you can address on appeal if you are convicted. I have been answering many of them at your request, but I may not do that at all times.
Yeah,
In
she's
fact,
not required.
you're asking me to provide that explanation and really highlight for the jury the court's opinion on relevance. That's why we don't state that. There's an objection, it's a party makes it, states the grounds. Sometimes I ask the opposing party for their position. Sometimes I do not. Many times it's very self-evident. Either
Yeah.
the objections are baseless. Many of the hearsay objections are baseless. Your objection to hearsay is it's not hearsay.
Yeah.
So that's why to me they're
He objects to
self-evident and say
hearsay
sustained, and we go forward.
and relevance
So you need
all the
to
time, and they are
be
not
aware,
applicable.
sir, that when you ask for the grounds, you're asking me to state a legal conclusion in front of the jury.
You're trying to coerce me into violating my right to remain silent. How can you coerce me into my right to remain silent?
What?
So you're not going to protect my constitutional rights? Because I didn't answer nothing that you was trying to ask me before when I had the headphones on, and you can't make a decision for me. You can't do that.
What?
You're violating my constitutional rights.
Sir, if you'd like to testify, then you need to simply go through the colloquy with this court, which I've given you 3 opportunities to do, and you have decided not to.
No, you can't tell me what I decided to do because I didn't decide to do or not do anything.
So yes, it
Yeah,
is a
see, no.
defendant's choice to testify. It is a defendant's right to testify.
Yeah, he has the right to testify. But he thought if I just don't answer, then nothing can happen. And court has to come to a halt.
Yeah.
And
He was delaying the trial.
yeah, he was trying to delay and whatever. He's like, if I don't answer her, because she asked him questions. She asked him, I think we counted when I was watching Nick Rekieta and Emily D. Baker. We were counting how many times she asked. She got up to like 8 times asking him, would you like to testify or not? And then right there, she said, sir, if you would like to testify, you need to go through the colloquy with me. And he said, oh, I don't see how you can decide because I didn't decide to answer or not to answer. Well, if you don't answer, that means I'm going to decide for you. Just like if the judge asks, do you plead guilty or not guilty, and you stand mute, then the judge will enter a decision of not guilty for you. Excuse me. Because the judge cannot enter a guilty plea for you, so the judge has to enter a not guilty plea for you. And if the judge asks you, would you like to testify or not testify? Your constitutional right is to not testify and to remain silent. If you don't answer the question, the judge is going to say, okay, I'm deciding that you don't decide to testify. And then if you say, oh, you can't decide for me, I never answered to testify or not to testify. Well, I asked you 12 times, sir, and you didn't answer. You're not going to hold up these proceedings by not answering. Otherwise, the first court case would still be going on. If you could get away with that, the first court case would still be going on. Because the person would not have answered anything, and, oh, well, we're just stuck. They didn't answer, so we just have to wait until they decide to answer. No, that's not how it works. If you don't answer, the judge gets to decide what's in the best interest of the defendant, and she maintained your constitutional right not to testify.
Silence is an answer.
Yeah,
I've
your
said that
silence is
before.
an answer.
No, I've said that before in personal life. Silence is an answer. If you ask someone a question, they don't respond.
That's an answer.
They're answering you somehow.
Yeah.
Even
Just
in
like,
personal relationships.
yeah. Just like all through the trial, if he would ask the judge a question and the judge didn't respond, he would go, a non-response is a tacit agreement, Your Honor, even though he was trying to say tacit. He would say, a non-response is a tacit agreement, Your Honor. Non-response is a tacit agreement, Your Honor. But when he doesn't respond, it's not a tacit agreement. It's not a tacit agreement. When he doesn't respond, you can't answer for me. You can't say I agreed to something. You can't answer for me because I didn't respond. But when the judge doesn't respond, it's a tacit agreement. Come on, man. You're an idiot. Just like you can appear as a third-party intervener for your client, but the DAs can't appear as a representative of the people of the state of Wisconsin. It's sovereign citizen bullshit. Like, I am not, what is it? I'm not prone to your rules and your jurisdiction. None of that applies to me. But what are you doing?
Oh, nothing. Just looking.
As a sovereign citizen, none of your rules apply to me, but I still have all my constitutional rights. But I don't have to obey any of your laws, and your court has no jurisdiction over me, but you better respect my constitutional rights. And the Fifth Amendment and the Sixth Amendment apply to me, but I don't have to abide by any of your laws or rules. Like, what? That makes no damn sense.
Nothing he says makes sense. That's why I
No.
have trouble listening to him.
Nothing makes sense. It's ridiculous.
I should be allowed to, and if that's the case, then I should be allowed to tell the jury what they need to know, which is the truth. That they have the power. They have the power to nullify laws and say over.
You are absolutely not allowed to tell the jury
No,
that.
sir.
There's a jury instruction that I will have ready to go if you even attempt to raise the issue of jury nullification, sir. You have absolutely no right to raise that. That is clear under the law.
I can raise what I want to raise.
No, you can't.
You should be informed that
Whoa, look at her face. Oh my god, her
you
face.
have the power
Sue Opera? Yeah.
Oh, she's mad.
to nullify any law that you don't agree with.
Objection, move to strike this statement.
Sustained. I
Objection.
will strike from the record the last statement made by the defendant. The jury will disregard it.
Which is clearly what I've been saying.
No.
I believe that not only is it fair, but it's essential that you be privy to all knowledge, not knowledge that
No.
certain people feel that you should hear and shouldn't hear, disguised under the color of law.
But you don't want the jury to know. You don't want the jury to know about your sex offender status. You don't want the jury to know about the fact that you ran over Erica with your car. You don't want the jury to know everything. You just want the jury to know what you want the jury to know. And you cannot argue jury nullification. That is illegal.
Oh god, the lady's face was funny.
Oh
She
yeah,
was
Sue
pissed.
Opera was pissed.
She's
She
"Don't
hates
say it,
him."
Don't say it.
Yeah, she hates him. Hates him. But trying to argue jury nullification, like, okay, jury nullification means, like, I'm sure you know already.
Yes.
I've explained it to you before, and you probably already knew about it before I explained it to you. But jury nullification is, okay, this guy got picked up for having a joint, and now he's in court.
Yeah.
And we on the jury are like, okay, why are they trying to prosecute this dude for having a joint? This is bullshit. I'm not prosecuting this guy. Yeah, that's the law. And yeah, the prosecution proved their case, but I'm not sending this dude to jail for having a joint. That's ridiculous. So you find him not guilty. Yes, you have the power, as he said, to nullify any law that you don't find justified, I don't know, whatever,
Yeah,
justifiable,
law.
yeah. You have the power to nullify that law by voting not guilty, regardless of what the prosecution said. But you killed 6 people. You killed 6 people and you ran over 60-something other people. Why would the jury nullify anything for you? Not to mention all your antics all throughout court. You've had them going in and out of court for 15 days because of your fucking antics.
They got more sit-ups and lunges done in that amount of time they probably ever had in their life.
Yeah, like Emily Baker
Exercise.
said. Emily Baker, she said, this jury got their steps in this trial. Yeah, they got their steps in because they'd be coming in and he'd be talking about subject matter jurisdiction or whatever, and the judge would be like, okay, take the jury out again. Before they even all sat down, the judge would be like, take the jury out. Because he was acting a fool. So why on earth would I nullify any law for you when you ran over and killed 6 people and hurt and injured 60-some other people? Kids, band members. Like, why would I nullify anything for you, bro? I'm not nullifying anything for you. Yes, I have the right to nullify any law that I think is unjust or unconstitutional, but guess what? intentional murder or vehicular homicide, I think that's a pretty just law.
Yeah.
And I think you should be convicted under that. Sorry. Good Lord. If that was his whole plan from the beginning. The judge said in her closing statements when she was talking about his sentence, she said it was clear from the beginning, because he said in his opening statement about the jury and their power,
Yeah.
and having the knowledge and knowing what they can do and blah blah. He was from the very sorry, excuse me. From the very beginning of the trial, he wanted to argue jury nullification.
I know. Yeah. That's
But
his
why would
plan.
they nullify? Why would the jury nullify anything for you, bro? You're a murderer. You're a child murderer. You had no remorse. You had no apology. We don't even know what your defense was. You never said I didn't do it. You never said I wasn't in the car. You never said I was forced to do it. There was somebody else in the car. You never said anything. All you ever did was, did you get a license plate? Did you see the defendant? Did you notice any tents on the car? Did you hear honking? Blah blah blah. You never said it was you driving. You never said I didn't mean to do it. You never said anything.
Nope.
You never gave any defense. God.
No. He does not have the right to argue jury nullification. Let me
Nobody
make that
does.
clear, because jury nullification is when a jury decides a case not based on the facts of the law, but for some other reason. Maybe it's based on politics or their emotions. This is absolutely prohibited. They are not supposed to do that. And you cannot advocate that a jury do that. Jury, I know that the prosecution may have proved their case beyond a reasonable doubt, but just ignore it and find me not guilty. Not gonna happen. And like I said, despite all of his efforts and seeming knowledge of the law, it didn't work. And he was convicted nonetheless.
Knowledge of the law.
And thanks so much, everybody, for joining us here on Sidebar. Please subscribe on Apple Podcasts,
No, he
Spotify, YouTube, wherever you get your podcasts. I'm Jesse Weber. Speak to you next time.
Bye, Jesse. Yeah.
It's horrible to watch.
What'd you think?
I think it's just like any of the other Darrell videos. He's horrible to watch. He's a crazy, uneducated, unknowledgeable. I don't know.
Yeah. He's
insane.
He's a sovereign citizen. He thought that would save him somehow. I don't know.
Hard to put into words this.
Yeah, I don't know what he thought he was doing. Like, he had no cognizable defense. He never said, it wasn't me in the car. He never said somebody was forcing me to do it. He never said the vehicle was malfunctioning. He never said anything. He just asked questions of the witnesses of, did you hear the horn honking? Or why would somebody be honking their horn? To alert people, right? Well, I never heard of anybody trying to hurt somebody while honking their horn. And it's like, yeah, but if you're honking your horn, that means you saw people in the road and you kept driving. Like,
I couldn't get through the barricades. The barricades were blocking me in, so
Yeah.
I had no choice.
the barricades were blocking me in. The little plastic barricades that you drove through at the end of the parade. You drove through them while that other cop was shooting at you. You drove through 2 barricades at the end of the parade, but all the other barricades... He never argued that, oh, I was trying to get out, but I couldn't. But all you had to do was stop, and the cops would have let you out. Like, he had no defense. He asked a bunch of questions about honking and barricades and tents on the windows and blah, blah, blah. He never had a cognizable, linear defense about anything. He just asked a bunch of random-ass questions to the witnesses and then argued for the jury to nullify. That's it.
It's horrible to listen to.
It makes no damn sense.
I'm excited when he's past all the news cycles
Yeah.
and YouTube cycles.
Yeah. Alright, guys.
Something better.
Thanks for watching with us.
Thank you.
We'll see you in the next video.
See you next time. Like and subscribe,
Yeah.
please.
Like and subscribe.
Because we would like to do this full time eventually.
Yeah.
Go on the road.
We'll try to
Buy an RV.
put more videos up. more frequently.
Yes.
Alright, see you guys next time.
It's been a busy few weeks, and we keep saying we'll explain it, and we never do, so we need to do a video just talking about ourselves for a few minutes.
Oh, we'll explain it later. Alright, bye.
Bye.